Without strong watchdog institutions, impunity becomes the very foundation upon which systems of corruption are built. Rigo Barta Menchu Tum. During the fall of the 1970s and the rise of the 1980s, the people of India were preferring to work in the capital market as the market was trending. Without any authority, unofficial self-styled merchant bankers started violating the rules and regulations of the stock exchange. Hence, the government felt an immediate need to establish a regulatory body, which led to the establishment of the Securities and Exchange Board of India in 1988 as a non-statutory body for regulating the securities market. SEBI became an autonomous body on 30th January 1992 and was accorded statutory powers with the passing of the SEBI Act 1992 by the Indian Parliament. Before the Securities and Exchange Board of India, the controller of capital issues was the regulating body to regulate the market, which was controlled by the Capital Issues Control Act 1947.
As we Indians rejoice in our journey of 75 years of independence, Sansad TV contributes to the said phenomenal journey by dedicating a series titled 75 Years Laws That Shaped India, a special program discussing different laws that have been adopted during these golden 75 years. I'm your host Hemant Batra, back with another episode in that exclusive series. Today we are discussing the Securities and Exchange Board of India Act 1992. In short, the SEBI Act. To talk about this groundbreaking legislation, we have with us a very learned expert panel, really extraordinary. Joining us is M. Damodaran, a highly accomplished corporate advisor, mentor, and a former IS officer, who has been the youngest ever Chief Secretary of any state when he was appointed as such in 1992. That is not all. He has also been the chairman of UTI, SEBI. Currently, he is the founder chairperson of Excellence Enablers, a well-known corporate governance advisory firm. Welcome, Mr. Damodaran. Welcome to the Sansad TV studios. We also are joined by Pallavi Shroff, iconic corporate, commercial and financial lawyer. Pallavi is the managing partner of Shardul Amarchand Mangaldas and Company, one of the big law firms in India and beyond. Pallavi has about 4 decades of experience in corporate and commercial law. Pallavi is also part of several high-powered law and public policy initiatives in the country. Welcome, Pallavi. Welcome to the Sansad TV studios.
Thank you, sir.
So let's begin our discussion for today. And let me start with you, Mr. Damodaran. Start with you with a very basic and fundamental question, though it is definitely significant, what I'm going to ask, essential in a manner that our audiences, our viewers are looking forward to response from you with regard to this particular question. And that is, what does SEBI do? What is its role? What are its powers and functions? You know, speaking theoretically and in real life, in terms of practically.
That's a good question. Even though it's a short question, the answer can be very long. I'll try and make it brief. Why did SEBI come into being as a statutory body? As your introduction said, it existed for 4 years prior thereto, and before that you had the controller of capital issues. But it was felt that you needed legislative backing for the kind of powers that were going to be exercised, and you needed a properly constituted body to exercise those powers. Now the key is in the preamble to the SEBI Act. It says 3 things: that SEBI is for the protection of the interests of investors in securities, it is for regulating the market, and it is for developing the market. All these three are really aspects of the same piece. If you develop the market, have more products, more participants, if you regulate the market, have orderly conduct in the marketplace, the result will obviously be that you're addressing the interests of the holders of securities. Now, what does SEBI do? There are two words I want to use which are not contained in the Act.
Right.
One is conflict of interest and the other is asymmetry of information. SEBI is on a journey to extinguish conflicts of interest in the marketplace and to reduce asymmetry of information, which cannot be extinguished. There will always be asymmetry. Therefore, all manner of market intermediaries are regulated by SEBI. There are regulations saying what they can do, how can they do what they can do, and what they should not be doing, and what the punishments are if you step out of line. SEBI is also an interesting body, and I'll say this, it's very important. Unlike many other organizations the world over, SEBI exercises powers of the executive, the legislature, and the judiciary.
Right.
Very few have that luxury or that responsibility, because it's not a luxury, this is an attendant responsibility.
That's an important point here.
And SEBI does that in order to ensure there's orderly conduct in the marketplace.
Right. Pallavi, the Act contains another significant set of regime or provisions, if I may say so. And as far as my understanding goes, these provisions were included by 2002 amendment.
That's right.
And those provisions at that time were very far-sighted provisions, I would say. These provisions I'm talking about are with regard to prohibition of manipulative and deceptive devices, insider trading, and substantial acquisition of securities or control, etc. Can you please tell our viewers about these provisions?
So, Section 12A of the SEBI Act, which came into existence in 2002, sort of outlaws or prohibits any activity that can disrupt the market. It sort of wants to protect the integrity of the market. So, three essential actions and acts of omission and commission that are prohibited are: one, anything that is fraudulent or disturbs the market. So that's the prevention or prohibition of fraudulent and unfair trade practices.
Right.
The second is prevention or prohibition of insider trading, which we call in short from the PIT regulation.
Right.
And third is the takeover, when you acquire certain number of shares. Or control.
Right.
In some form or the other, then you have to do a public offer so that the minority shareholders can decide whether they want to stay with the new promoter or the new majority shareholders or not.
Right.
So this section actually gives power to SEBI to enact various detailed regulations
which are already there.
Which have now come, the regulations have been there, but this was the power, the source of power.
Absolutely.
And there are regulations which you call the FUTP regulations.
Right.
Prevention of fraud and unfair trade practices. You have the prevention of insider trading regulation.
Right.
And you have the SEBI takeover code regulations.
Fantastic.
So these are the three regulations which have come. The source of power is Section 12A.
Right.
And the basic purpose is protect the integrity of the market.
Of the market.
Yes.
Right. Very well said. Mr. Damodaran, there are a whole lot of penalties which are laid down under the statute for contraventions of the provisions of the Act. And obviously they are preceded by an adjudication process coupled with settlement proceedings by the SEBI. Can you please enlighten our viewers with regard to this set of adjudication process and even the settlement proceedings?
As in every sensible system, you need to factor in natural justice. And natural justice necessitates that you hear the person who is accused of an offense. So SEBI's process starts with collecting information that is surveillance. Then put together, if you find something wrong, put together something which is calling for explanation, not necessarily a charge sheet. Hear the other party. Are there circumstances in which this could be justified, the conduct that you believe was questionable prima facie. And if that's not so, then you get started on a proceeding which could be, depending on the nature of the offence, entrusted to an adjudicating officer who is not lower than a division chief in rank. Serious matters also go to the whole-time member, which is one level below the chairperson of the board. And
sorry to interject you here.
Yes.
There's one question which is bothering me, and I'm sure that will be bothering many of our viewers. That can a common man also bring to the attention of SEBI any contravention which would have been done by any corporate body or any broker at the stock exchange?
The common man can certainly bring it to SEBI's notice, but unlike in the case of proceedings in courts where a common man could well be the petitioner, here your duty stops when you bring it to the notice of SEBI.
Just by
SEBI looks at it to see whether there is any material warranting further action and then takes its own process.
On settlement proceedings?
Settlement is an interesting development. In fact, it was introduced during my tenure in 2007 because we found that there were a whole lot of cases, some which had systemic importance, some which were trivial. And you didn't have to have the trivial queuing up ahead of the others to get regulatory attention. The United States already had for many years a tried and tested system of settlement. Therefore,
plea bargaining and
we introduced a consent mechanism where you could go and tell SEBI, I want to settle this. And the interesting thing about the settlement mechanism is that the order itself states that this is without a person either pleading guilty or not guilty. It is without a plea
so
of
it does not
guilty or
stigmatize
innocence.
them in that sense.
And that is why many organizations find it useful instead of going for protracted litigation, even when they believe they are right on occasions. They don't want to commit valuable time and resources. Therefore, they say, let's settle this and go on with life. And it's working very well.
Thank you. Well, it is time to slip into a very short break. Please don't go anywhere, as we'll be back soon. Welcome back after the break. You're watching our special show on selective landmark laws legislated during our journey of 75 years of independence. Today we are discussing the Securities and Exchange Board of India Act 1992. Before we get on with our discussion with the experts, let us glance through the parliamentary journey of this act.
On behalf of Union Finance Minister Manmohan Singh, Minister of State in the Ministry of Finance, Rameshwar Thakur introduced the Securities and Exchange Board of India Bill in Lok Sabha on March 3, 1992. The bill was passed by the Lok Sabha on March 30, 1992 and by the Rajya Sabha on April 1, 1992 respectively. It received presidential assent on April 4, 1992. The SEBI Act 1992 was deemed to have come into force on the 30th of January 1992 as this act was preceded by an ordinance. Let us view and hear some of the significant debates in Parliament on the said Act.
The main powers and functions of the board relate to regulating the business in stock exchanges and any other securities markets, registering and regulating the working of stock brokers, sub-brokers, share transfer for agents, merchant bankers and other intermediaries in stock markets, registering and regulating the working of collective investment schemes, including mutual funds, and prohibiting insider trading in securities.
This bill has got nothing new, excepting giving statutory power to the board, which it did not have. What actually does the government intend to do? And in what way? for bringing stability to the share market and for really protecting the investors, particularly the small investors.
We in the BJP entirely support this piece of legislation. We support the granting of statutory authority, powers and status to the Securities and Exchange Board of India. Though I do support my esteemed friend and colleague Srimati Geeta Mukherjee in her procedural point that it would have been more preferable had this not been brought about through the means of ordinance.
Moving on with our discussion in the second round, let me come to you first, Pallavi. Pallavi, I'm sure there would be several judgments, judicial precedents with regard to this particular statute, interpretation of some of its key provisions. Can you please share any landmark judgment regarding this particular statute?
So before I get into discussing couple of important judgments, I think let's start looking at what is first the FUTP and what it covers in very, very brief. So FUTP regulations actually cover any fraudulent practices that may be engaged in or any market manipulative practices. Let me give you an example. If there are a group of 3 brokers who actually engage in what I would call a circular trading, I sell to A sells to B and B again sells it to me, this would create a false demand for those shares which conveys to the public that these shares are in demand. It could also lead to price increase. And then people want to invest in those shares. So when actually it's only 3 of us who are doing the trade, that's not a real trade. So this sort of is a market manipulation. Of, you know, the whole market.
Share price and
price, the number of shares, the demand for shares, sort of sending out a message, come and invest in these shares. Take a second situation where a company actually the books of the company are not genuine. Either there is a markup or something false in the books which actually shows the company to be in a better financial health than it is actually. Again, that sends out a message. Actually, it's misrepresentation and fraud, but people are led to believe that they should invest in this company because it's a healthy company. So there are 2 different aspects that we could look at. Both could have different consequences. When you look at the prevention of insider trading, I think you look at a situation where maybe I as a director or as somebody working in the company or somebody very senior up in the company have very sensitive, price sensitive, unpublished information, what we call UPSI, unpublished price sensitive information, and I use that information to undertake trading.
I see.
Or I share that information with someone else and someone else does the trading on my behalf, but I gain at the end of the day. And this leads exactly to what Mr. Damodaran was saying earlier, that the market regulator, which is SEBI, wants to prevent asymmetry of information. This is typically information that I may have because I'm on the board or any other reason, but which the general public does not have. And should have been available with the general public, the price of the shares would have got impacted. Either I would have bought now and sold later at a higher value, got some benefit or the other. So that's the prevention of insider trading regulation. And the third one, which is the SEBI Takeover Code, if you acquire, say, a certain prescribed amount, say 25% and more, then you have to give the other minority shareholders their ability to exit because they may not want to continue with a new principal shareholder. And then there are whole regulations around it with some exemptions, and the whole process and procedure is prescribed. So that is the SEBI takeover regulations. The takeover could be direct or indirect. It could be takeover of shares and not necessarily only shares. It could also be takeover of control. And control does not, even without the shares, you could buy over debt which could have a lot of control. Control could be ability to appoint majority directors on the board or to otherwise influence the policies and decisions of the board or of the company. Very interestingly, the one case that I want to refer here was the Shubhkam case way back, which SAT had taken as to what is control. It's such an ambiguous word. And they had, SAT had said, the SEBI Appellate Tribunal ultimately said that if you have positive rights where you can actually influence. It's like, you put your foot on the pedal and you run the car. So when you have the ability to run the car and take positive decisions, that would deem to be control. But if you have negative control, which are typical investor protection rights, which you say you will not have a new line of business, or you will not take more debt without my approval, those sort of clauses are investor protection and they do not actually signify control. Supreme Court in another context of the IBC actually upheld that decision.
I see.
And said, yes, control means only positive control and not negative control. So that concept has actually been taken forward and now accepted by the Supreme Court. Though other regulators tend to take different views. The competition regulator, for example, takes a completely different view of that. Insofar as the FUTP cases, I think the recent case of Abhijit Rajan versus chairman of SEBI is quite important and significant, because typically when it used to be that you did something wrong or there was a fraud or a market manipulation, take a case where you created a false market. If you did that, then certainly you were booked, like, SEBI came down and said, yes, you have done wrong. The Supreme Court very recently, maybe last week or something, has actually said that there is one more aspect which has to be looked at, whether you had the intent to make gains or not. And in that
kind
case,
of a mens rea principle.
No, they distinguish between mens rea and the intent, because in that case, Abhijit Rajan sold his shares to comply with his obligation of funding a corporate debt restructuring. So he had information which was going to be beneficial. It would have actually increased the price of shares, but he actually sold it before that, didn't wait for that. So that what they said, no, he did not have the intent as distinguished from mens rea. So that's a very nuanced argument and a nuanced decision.
There is a thin line.
It's a thin line, but yes.
Very relative, subjective, I would say, application.
Yes, normally one would think, well, this is mens rea, is now mens rea required for FUTP, when you know this is like market manipulation or whatever. But I think the Supreme Court has, it's a new gamut and a new nuance which we'll need to discuss as
So as Mr. Damodaran, Pallavi was mentioning about Securities Appellate Tribunal.
Yes.
Can you please tell us about its dispensation of justice mechanism and jurisdiction?
Let's look at its origins. Before it came into existence, appeals against orders passed by the chairman SEBI, there were no whole-time members then, were considered by a two-member committee of the Ministry of Finance, and that was clearly an unsatisfactory way to deal with appeals, because you didn't have domain expertise at that level, you might not even have had legal training to look at those appeals. So then you had a single-member SAT, one member. Later it became multi-member, the chair, presiding officer and two members, and now it doesn't look at only orders of SEBI. Its remit has been expanded. Now it looks at appeals against the insurance regulators' orders as well as the PFRDA. So clearly it is a body that has established its credibility. I want to step back a little in the context of what was mentioned earlier by Pallavi, which is the UPSI, etc. One of the features of the SEBI Act and what it actually sets out to do is to promote a disclosure-based regime. So from 1992 onwards, or from 1988 really, you have moved from what was called a merit-based scheme, where merit like beauty lay in the eyes of the beholder, the controller of capital issues. He decided what was right or what was wrong. So you've moved now to a disclosure-based regime. Disclose everything. If something is material, put it out on the website of the exchange. Now going back to SAT, I think a lot of people found in the initial days that SAT also was slowly settling down, etc. Some of the earlier orders you could question with the benefit of hindsight, But now you have a system where you have a former Chief Justice as a presiding officer, a judicial member who is a judge, and then you have a technical member. It's a 3-member body. They do look at a lot of things. And one additional point I must say, which will help to clear a misconception. A lot of talk is there about almost all SEBI orders get reversed in SAT, which is completely untrue. Because the former SEBI chairman, the immediate predecessor, did show me statistics to show that something like 85% of the orders were upheld. There were clearly some orders which were not appealed against. But then again, the ones that go wrong are the ones that get column centimeters in the newspapers. So it's important to remember that institutional credibility should not suffer because of misconception. That's the point I was making. And I think it's a good track record.
Thanks for clearing that air. Definitely that misconception was created by media as well to some extent. But good you cleared that air.
If I may add just one point, Mr. Damodaran, would it not help? There was some judicial training given to those who do the adjudication process at SEBI to avoid some of the simple mistakes, as I would say, which because of which the orders get reversed at the SAT.
No, I think what you're saying is right. You don't get people there who have prior legal knowledge or training. There have been proposals in the past to get that done. Somehow it hasn't worked, but you're touching on a larger subject, which is capacity building in regulatory organizations. If you don't build capacity, they will always struggle to keep pace.
Even if you don't have a lawyer or a judge, but just some training, just training.
It is time to take the viewer's question. The question is being asked by a law student, Amisha Arora. Let us listen in.
Are chartered accountants, company secretaries and cost accountants permitted to appear before the Securities and Exchange Board of India and the Securities Appellate Tribunal?
Pallavi, will you take this question? It's obviously yes or no kind of a thing.
It is a yes.
It is a yes.
It is a yes.
Okay. So, and this is a statutory right?
Yes. I think it's section 15.
Right.
5.
So chartered accountants, cost accountants, company secretaries can appear.
Correct.
Well, the stock market is filled with individuals who know the price of everything, but the value of nothing, said Philip Fisher, author of the popular publication Common Stocks and Uncommon Profits. In that context, I think SEBI has played an important role to educate people regarding shortcomings, nuances, and risks associated with the securities market. The real value is added in the form of knowledge and reforms. Thank you so much, M. Damodaran, Pallavi, Shroff, for joining us, educating our viewers and audiences with regard to the effect, impact, and significance of the SEBI Act.
Thank you.
Thank you. It's a privilege. Thank you.
Well, that's all we have in this edition of the program. You can also connect with us on various other social media platforms. Thank you for watching. Goodbye and namaskar.